Hello, welcome, Employment Law Show. Good to have you along once again. John Scholes here, Lior Samfiru right beside me. Coming up on the show today, what your employer legally can't do, part 2. We did part 1 a few shows back, if you remember that. We got the other half of that list to get through. So a busy show, some phone calls from our radio show as well. Anytime you want to find out, hey, where do I catch that radio show? employmentlawyer.ca, the website, take you to the firm website right there and search. You'll find one across the country, and you can tune into that show every week as well. But Lior, as you know, we start the show every week with the week that was. What do you got going on?
Well, John, you wouldn't be shocked to hear that I've been answering a lot of questions. I've been getting a lot of emails, a lot of phone calls. It seems like that's all I do. Every time I try to step out, maybe grab a bite to eat something in the kitchen, I get pulled right back in with some emails and calls. That's okay. I want to do that. I'm going to continue answering questions as long as questions are coming. So if you want to know about your workplace rights, if you're facing a workplace problem, well, guess what? There are solutions, and the easiest way to get those answers and those solutions is to reach out to me. We'll give you that contact information throughout the show. But that's for after. For right now, we're going to cover a lot of topics that are relevant. We only pick topics that are relevant, that a lot of people are facing or want to know about. So we'll answer a lot of questions that you have just by you watching this show, of course. So I'm glad you could join us. Hopefully you'll find the next 30 minutes to be useful. And to get us started, John, we call it the week that was. Rather than tell you about a specific situation that I dealt with, I'll tell you probably the most common question that I've been getting for the past number of months. I think we've talked about it on a previous show, but I have to talk about it again, and that is the issue of vaccinations. Having a vaccine or getting a vaccine, and whether you have to get one, or put it differently, can your employer mandate that you get a vaccine? Can they tell you, you better get a vaccine? I had a call earlier today where the person that called me said their boss said that he has to get a vaccine within 2 weeks or else. So let's discuss this. Now, keep in mind, this is all a new issue. We didn't have to worry about these things till a global pandemic hit. But bottom line is this: unless you're in a job that cannot be done safely, unless you get a vaccine, then your employer cannot make you get vaccinated. It cannot. Now, in some situations, a narrow set of circumstances, you may be working in a facility like a hospital or elder care where you're face-to-face with very vulnerable people, and there's no other way to protect you or others. In those very limited set of circumstances, your employer may be able to say, yeah, you have to get a vaccine. For most everyone else, your employer cannot mandate or require you to be vaccinated. Now, your employer could, in some cases, ask you whether you have been vaccinated. And the reason for that is your employer may need to know if you haven't been vaccinated, maybe you need to continue working remotely, or maybe we need to be extra careful with respect to mask wearing and social distancing. So it's okay to ask if you've been vaccinated so that the employer understands what its obligations are within the workplace, keeping everyone safe. But it is inappropriate and it's offside for an employer to say, you have to be vaccinated, you can't work here unless you've been vaccinated. If you are facing threats to your job, if you are facing ultimatums, if you are facing situations where there's pressure being put on you because of the vaccine, if your choice is ultimately not to get it, you can do something about it. Give me a call in those situations. Your employer should not make you, force you, or threaten you with respect to the vaccine.
You know, it's interesting too, depending on the occupation. Do you see that changing over time? And I mean, if you're a hospital worker, yes. If you're working long-term care, yes. I could see the definite reason why you'd want to be and have to be. But I mean, you got to think about something like the food service industry. Your waiters are going around, to different people, different tables. They were the first ones to get shut down and probably the last ones to open up again. Could their bosses or their employees say, well, they're in direct contact with the public, you have to get vaccinated, or they can't do that?
Well, if public health says that you can still do your job safely, okay, if the public health authorities, then the employer can't decide, well, we say that you can. So we have to rely on our medical experts for that. It's inappropriate for a boss to say, I've decided it's safe or it's unsafe. We have to rely on the guidance that we're getting from the government, from the health authorities. That's the way to go. So if the government says, if public health says, yes, you can do your job safely even if you haven't been vaccinated, then the employer can't do anything about it. It's going to have to be up to the government to say, these jobs have to be vaccinated, these jobs not. If they don't do that, an employer can take that upon themselves to decide what's appropriate and what isn't.
By the way, questions for Lior, if you have any after the show, which I'm sure you will. He gets enough of them. It's 1-855-821-5900, help@employmentlawyer.ca and justemploymentlawyer.ca, the website. I mentioned off the top, that's where you go to catch a radio show across the country that carries our broadcast every week. We get the phone calls from that show. We play them back on here each week, Lior, because they're pretty interesting, the phone calls that we pick, and they cover a lot of bases and are of interest to a lot of people. So I want to get a phone call number one for this week right now.
I work as a technology sales rep, and what we did was we sold all sorts of technology that are utilized in schools, to schools, and education. I had worked for that company for about 2.5 years, and then the pandemic hit. I was let go. The reasoning was kind of vague to me, but understood that COVID is not allowing this company to make as much money, so they have to let people go. I was given my severance, the 2.5 weeks pay, but I'm not sure if they were even allowed to do that to begin with.
Mm-hmm.
So there's two separate issues here. Number one is whether or not his employer could let him go at all. And number two, the issue of severance and how much severance he's owed. So let's deal with the first issue. And the answer in that situation is yes, his employer can let him go, whether it's COVID-19 related or not. The general rule is your employer can let you go as long as they pay you severance. You may not have done anything wrong. You may even think, well, wait a second, the business is doing very well. There's no need to let me go. Despite the fact that there may not be a business reason or a financial reason, an employer can choose to let someone go. So in most cases, unless we're talking about discrimination, where you've been let go because of your age or disability or ethnicity, if that's not the case, if it's not discrimination, usually an employer can let you go for any reason. But that's when we get to our second point, which is severance. So this person we know has been let go. He said he's been there for 2 years, 2.5 years, and he was paid 2.5 weeks pay. No. He is owed much more than that. Depending on his age and specific job that he had, it could be as much as 6 months pay. Not weeks, months pay. So if he was paid 2.5 weeks, but he's owed 6 months, even if he's owed 5 months, that's a huge difference. So this is actually a wrongful dismissal. It's not a wrongful dismissal because his employer let him go. His employer was allowed to let him go. It's a wrongful dismissal because he's owed a lot more than 2.5 weeks pay. Same with you. Chances are, if you've been let go, the termination itself was okay. It's a matter of severance, and you're probably owed a heck of a lot more than what you've been offered.
There's another place you can ask questions anytime. Want to mention this, we cover it all the time. Terminationquestions.com. Terminationquestions.com is a good place to go. John, this week writes in, says, I was fired after I was unable to bring up my department's performance over the past 2 months, despite the pandemic and my best efforts. Even after 7 years with the company, I was told that I'm not owed severance because I failed to meet their benchmarks. Is that right? I'm 55 and never signed a contract.
Well, John, I get a question like this or variations of it very, very often. The company says, I'm just not up to snuff. I'm not doing the job the way they want me to or to the level that they want. So they've let me go. Can they let me go for cause? And the reason we care about this idea of termination for cause, it's because if the company does in fact have cause, they don't have to pay severance. Here's the thing. It is very difficult to terminate for cause, exceptionally difficult. And the fact that this employee may not have done his job at the level that the company wants, that's not cause. For it to be cause, the company would almost have to show that he was deliberately slacking off or trying to avoid doing his job. If he's doing his best, he's not meeting the company standards or milestones, that's going to be extremely difficult to terminate him for cause. The company can still let him go. Remember what I said a few moments ago. A company can generally let an employee go, but it's not cause. It would be a termination without cause, and he would be owed his full severance. So I want to remind everyone there that you may have done something wrong, or your performance, whether it's because of the pandemic or otherwise, may not have been all that it should have been. That does not mean you can be let go for cause. That does not mean you lose even $1 from your severance. So we know now, based on what this person said, that he is owed severance. He's owed his full severance. So let's go to pocketemploymentlawyer.ca. Let's plug his information into our severance calculator tool, and let's see how much he's actually owed. So we'll turn it over to pocketemploymentlawyer.ca. We know that this person has been there for 7 years, 55 years old, and he was told no severance because we have cause. We've already established that that's wrong, and we see at the bottom that he's owed actually 8 to 9 months of severance. 8 to 9 months. So we've gone from zero, what the company said, to as much as 9 months pay. That's why it's so important to understand what you're owed, to understand when it's caused, when it's not caused, and of course to understand how much severance you're actually owed if you lost your job.
What we are tackling next, what your employer legally can't do, but we'll take a quick break first before we get to that. 1-855-821-5900. Email to reach out, help@employmentlawyer.ca. Coming right back. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Employment Law Show is what you're watching. Anytime you want to reach out, 1-855-821-5900 and pocketemploymentlawyer.ca is also a great website. Absolutely free, anonymous. There is contact at the top right if you want to use it. All right, let's get into the topic for today, Lior, what your employer legally can't do. We're starting off strong with the first one, force you to accept a new employment contract. How about that?
We're starting off at a 10 and we're going to take it up to a 12 really quickly. But the reality is that an employment contract is not your friend. A written contract of employment, if we're talking from the perspective of the employee, is not something that you want to have necessarily. You are far better off not having signed a written employment contract, having a job where you signed the back of a napkin or you simply did it the old-fashioned way on a handshake. So if you have not signed a contract, or even if you did sign one before and your employer now says, now we want you to sign a contract, a new contract, be very concerned. There's a reason your employer is going to come out of the blue and want you to sign a new contract. And it's not because they've decided they want to do something better for the employee. It's because it provides for better terms for the employer. For example, that contract that your employer wants you to sign could limit your future severance, could limit it to a fraction of what it otherwise would be. It could cost you tens of thousands of dollars. Or it could give the company the right to lay you off temporarily. Or it could give the company the right to change your job duties or change your compensation. Or likely it's going to do all of those things and more. So whenever you're asked to sign a contract of employment, be very concerned. And remember, your employer cannot force you. It's not considered misconduct if you say thanks, but no thanks. So before you even think about signing that contract, you have to know what it says and what you could be giving up by signing. How do you do that? Easy. You reach out to me. You contact me, then you send me a copy of that contract. You can email it, you can fax it, whatever you want. I can take a look at it and let you know, is it a problem? Is it not a problem? And how do we respond to the company? But no, your employer cannot make you sign a new contract of employment. And in most cases, you should absolutely refuse.
Something else your employer cannot do legally, and that is they treat you like a contractor when you're actually an employee.
So we talked about this topic on a previous show, the idea that many employees are in fact misclassified. They're employees, but they're called something else. They're called independent contractors. They are misclassified. And that's a very common thing. And your employer cannot just decide to change your status to call you something that you're not. If you look like an employee and if you act like an employee, you are an employee, and it's not up to the employer, to the company, to say otherwise. So your employer should not treat you like a contractor or call you a contractor or pay you like a contractor if you are an employee. In fact, your employer should be paying you your overtime pay and your vacation pay and your minimum wage and, of course, your severance if you lose that job. By the way, we mentioned pocketemploymentlawyer.ca. One of the tools there is the tool that allows you to find out if, in fact, you are an employee or an independent contractor. You can do that right now. Grab your smartphone, your tablet, desktop, what have you. Go to pocketemploymentlawyer.ca. You'll see that tool. Answer a few questions. You can find out whether you're an employee or an independent contractor. Use that information. And by the way, it's anonymous and free. But your employer can not just decide to save money to make its life easier by misclassifying you, by calling you something that you're not.
Okay, number 3, your employer is not allowed to withhold pay or take money from your paycheck either.
Very important. If you owe the employer any money, if your employer believes that they should be able to take something off your check, they cannot do that without your written consent. So your employer can only deduct something from your pay if you've consented to it in writing, even if you owe the company money. So let's say something that, like, the company, you damage something of the company's. Right. So the company says, okay, you owe us $1,000. We're going to take it off your check. No, unless you gave them consent in writing. So your check, your pay, your compensation is sacred. Okay, the law looks at it that way, and that nothing can come off it unless you've consented in writing. If you have an issue there, if you believe your employer is deducting things they're not supposed to, for that issue and not many others, you can go to the Ministry of Labor and you can file a complaint against your employer because, as I said, your employer cannot deduct things off your pay without your written consent.
That also includes pay reductions, I guess, as well, right?
Yeah, pay reduction is even different. An employer that decides to say, well, instead of paying you $20 an hour, we're going to pay you $16 an hour. Well, that's a significant change. That's a constructive dismissal. Whenever you're facing a significant pay cut, more than, let's say, 10% or so, 15% of your compensation, now you have to think constructive dismissal. Now you have to think, wait a second, do I accept this pay cut, continue working, or do I say enough is enough? By cutting my pay, you've terminated my employment. I want my full severance. You have that right if you are facing a pay cut.
What your employer legally can't do to you, fire you for cause unless there's serious misconduct. It's a high threshold too, right?
We touched on it before our previous break, how difficult it is to terminate for cause. Yeah. Now, that does not stop employers, unfortunately, from trying. I've seen hundreds and hundreds of matters over the years where the company says, oh, no, we've terminated you for cause, but it's not close to rising to that level. So that is a common thing. That's what a wrongful dismissal is. So your employer can only let you go for cause if you've done something bad, if you've done something so terrible that makes it continued employment impossible. That's a high standard. And most employees, even if they've done something wrong, they haven't done something that bad. They haven't stolen, they haven't hit someone, they haven't committed fraud or forgery. So if your conduct or misconduct is not that bad, you cannot be let go for cause. And the reason we have to distinguish between cause and no cause is all about severance. The difference could be as much as 2 years' pay between being let go for cause or not quite meeting that threshold of cause. You could be owed significant compensation. Give me a call if you lost your job, whether it's cause or no cause.
The next thing they can't do is discriminate against you in the workplace. This one's hugely obvious, but they still trip over that line.
They do, and sometimes it's intentional, sometimes it's not. We all have a right to work in a harassment and a discrimination-free workplace. We should never be discriminated against based on our age, our ethnicity, our sex, our gender, our sexual orientation. I can keep going. And those are very fundamental rights. In fact, they're so fundamental that we have human rights legislation that protects our rights to be free from discrimination. An employer has to protect us. They can't implement rules that discriminate against us. They can't avoid hiring someone because of a discriminatory reason, or they can't fire someone because of a discriminatory reason. And if any of those things happen, that's a human rights violation. That could be something that may give you significant entitlements and there could be significant repercussions against that company. So yes, you cannot be discriminated against. If you even have the inkling that that's what's happening, you have to reach out to me right away.
And we'll get to one more of these things that the employer cannot do to you legally, and that is pay you less severance when you are owed more. It's what the law says.
That's what the law says exactly. Yet 90% of employees, 90% of employers, when termination of employment happens, employers pay less or offer less severance, a lot less severance than what they owe. So we talked about the fact an employer is not allowed to do that. Most employers either knowingly or unknowingly do that. They offer less severance because they hope and believe that the employee won't know any better. And you know what? Most employees, unfortunately, don't know any better. But guess who does? You. If you're watching our show right now, you know better. You know what you're owed. You know how to calculate your severance. You know that 90% of people, when they're let go, are owed a lot more than what they've been offered. You can go to pocketemploymentlawyer.ca. You can give me a call. You can send me an email. There's so many ways to ensure that you get what you're owed. And the difference between what the company says they're going to pay you and what the company actually has to pay you often is tens of thousands of dollars. So please do not walk away from rights that you have when you really don't need to, when it's easy to resolve these issues.
Take a short break in a minute, but first I want to get to phone call number 2 from our radio show. Again, employmentlawyer.ca to find a station that carries that broadcast. Lior, let's get to it.
I'm an owner of a retail store. I have an employee that's been with me for 2 years. She, through a text message, informed me that she's going through some panic attacks, has indicated that she'll take a week off. The answer to her was, of course, we hope you feel better and, hopefully we'll see you next week. Now it's coming to that end of the time. Do I have the right to ask her, what's the status?
Certainly something that, first of all, I'm happy that this employer is asking that question. That's a smart employer. That's a proactive employer, an employer that understands that he needs to find out his obligation so that he doesn't accidentally do something illegal. So let's start with the idea that an employer can ask for a doctor's note. If an employee needs to be off work for medical reasons, it's perfectly legitimate to say, okay, that's fine. Give me a doctor's note when you can, just to verify that. That's reasonable, and there's nothing wrong with that. The other thing an employer is allowed to do, as this employer has asked, is to find out what the status is, to get an update, whether it's from the employee or even from the employee's doctor. That does not mean that an employer can ask, well, tell me what your medical condition is. You can't ask questions about the employee's diagnosis. Doesn't matter if they have anxiety, depression, or a herniated disc in their back. That's irrelevant. You can, though, ask questions about prognosis. Tell me how long you're going to be off. Tell me what accommodation you need. Tell me when your doctor is going to give us an update. That is fine. Those are legitimate questions. An employer doesn't just have to sit and wait in the dark and hope that the employee contact them. The employer can be proactive, but again, not crossing the line into diagnosis. That's inappropriate.
Let's take that short break, Lior, and come back with another phone call from the radio show, 1-855-821-5900 and employmentlawyer.ca. Coming right back.
People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back. A few minutes to go. Some more stuff to cover here before we wrap for this week. Lior, again, employmentlawyer.ca. That website is also where you want to go to catch a station that carries our radio broadcast. Phone call number 3 is coming right now.
I have been approached by my employer to transfer from a job that I've been doing with the company for 8 years to an inside job. So it would be a new pay package, a new contract, and all of that. I would go from 6 figures down to whatever we haven't agreed on yet. And I'm wondering about how that would affect my severance, all things being equal.
It's a great question. It's certainly something that he should think about now, not later on when it's too late to do something about it. So let's start with the idea that his employer does not actually have a right to force this change. So the employer can't decide, we're going to change your job, we're going to change your compensation structure, your terms of employment. None of that is possible. And if the employer decides to try to do that anyway, to force the issue, then that's a constructive dismissal. He can say, well, you've terminated my employment in your conduct, in your treatment of me. Now you have to pay me my severance. But if he doesn't want to do that, if he wants to work with his employer, here's the concern. If he's going to agree on less pay, so he's going to say, well, instead of getting paid $100,000, I'm going to get paid $80,000. Well, number one is he's making less money, but number two is this. Let's say a year from now, he's let go. Now the severance he's owed is going to be calculated based on that reduced amount, based on the $80,000, not the $100,000. So he could be losing tens of thousands of dollars in severance as well. So you have to understand that if you agree to a lesser pay and then you are let go, now your severance is calculated based on that new pay, the reduced pay. That could cost you a lot of money in terms of severance. Now, I mentioned constructive dismissal. I mentioned that he could say today, if his employer forces this change, no, you've terminated my employment. I've decided that I want my severance. So let's look at how much severance he's actually owed. Let's take his information, as we always do, and let's put it into pocketemploymentlawyer.ca, our severance calculator tool. You can see that on your screen right now. So this person, let's say he's 60 years old. We know he's been there for 8 years. He said he's making a 6-figure income. Well, if his employer is going to change his terms of employment, if he chooses to say that's a termination, he could easily be owed as much as 14 months' pay. You can see that on your screen right there, 14 months' pay. That's what's at stake for him. And same with you. If you lost your job or are facing a constructive dismissal or are even worried about losing your job, you can find out now for free and anonymously how much you're owed. Just go to pocketemploymentlawyer.ca.
Want to get to one more stop at terminationquestions.com. Lior, the last couple minutes. Elliot says, I've submitted multiple email requests to HR for accommodation due to a medical condition. Company hasn't responded to any of them or follow-up calls. However, my manager has just requested a morning meeting next Thursday, along with a member of HR. Should I be worried?
Well, it's obviously difficult to know what's going on in the employer's mind. It's certainly possible that this meeting with HR is to determine what kind of accommodation this person needs and how the company can accommodate him. And if that's the case, then the company would be doing everything right. I'm certainly concerned that the company so far hasn't been cooperative. Remember that if you need accommodation, if you have that doctor's note, your employer has to find a way to accommodate you. Whether it's modified duties, modified hours, they have to make it happen. But if this person ends up being let go in this situation, well, now we've taken a bad situation and the employer has made it even worse. Now it's even a worse human rights violation if they let go of someone because of a medical issue, because they need accommodation. That's illegal. His employer cannot do that at all. So Elliot has to keep that in mind. If his employer won't accommodate him, or God forbid he's let go, he picks up the phone right away and he calls me without hesitation.
And the concept of accommodation, that increases the bigger and more robust the company is, right? They have more resources.
Absolutely. The bigger the company, the more positions are available, the more resources they have, the more is expected of them in terms of accommodation. It's going to be very hard for a big company with a lot of resources to say, oh gosh, that's just too much. We don't have to accommodate you quite that far. No way.
Lots of good stuff there today. We're going to wrap it up, leave you some contact to move on. Employmentlawyer.ca is the website. help@employmentlawyer.ca, the email we always go to. Phone number 1-855-821-5900. And finally, pocketemploymentlawyer.ca. First place you go, even before that phone call. Appreciate your time. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.